Hi everyone, I'm Lauren Bernard. I'm the marketing director here at McMurray and Schuster, and I'm having another conversation with Counsel today. I'm here with Aaron Parry, who is one of our associate attorneys with the privacy practice area. Today we are going to be talking about health data privacy laws. Before we dive in, I just want to make a note. We would not be a law firm if I didn't throw a disclaimer out there. This discussion is not going to constitute legal advice. This is for informational purposes only. We know that every business has unique circumstances, and so when taking into account your business's responsibilities under these laws, you really need to work with counsel that is experienced with privacy and compliance. So with that, I think we will dive right in. Health data privacy laws. So, Aaron, I feel like we hear a lot about comprehensive privacy laws, these state laws, California's CCPA, Colorado, Virginia, get a lot of coverage and a lot of discussion. These laws that are coming out that have a narrower applicability don't seem to get the same press and the same attention. So what's going on right now?
Well, yeah, you're right. Generally, the comprehensive privacy laws come top to mind, but there's been a lot going on in 2023. There's been several states that have introduced child privacy bills. Recently, the president just issued an executive order on artificial intelligence, and then 3 states have enacted consumer health data privacy laws. That's Washington, Nevada, and Connecticut. And these consumer health data privacy laws introduce nuanced compliance obligations. So businesses have to really examine these laws to determine what they might have to do to comply. I have 5 of the more nuanced obligations that I think are really important. So I'll dive in. The first is the applicability of these laws. All 3 laws apply broadly to any business that conducts business in the applicable state or produces products or services targeted to residents of those states. There's no consumer collection threshold, no revenue threshold, or no monetary threshold. So if your business didn't have to comply with these comprehensive privacy laws, it doesn't mean that you might not have to comply with the consumer health data privacy laws.
Important to keep in mind. So consumer obviously is at the heart of all these laws, consumer protection. What's the definition of a consumer under these laws, or for that matter, consumer health data? What does that actually mean?
The definition of consumer in Washington and Nevada is a little bit broader than we're used to. It's defined as a resident of the applicable state or an individual whose consumer health data is collected in that state. So a little bit broader than we're used to.
Yeah.
Connecticut's, on the other hand, is more aligned with our comprehensive data privacy laws in that it defines a consumer as a resident of Connecticut. Consumer health data is a pretty inclusive definition, a lot broader than one might expect, and is defined as personal information that is linked to or reasonably linkable to an individual, and that indicates that individual's past, current, or future health status. In Washington and Connecticut, that would include health diagnosis, health treatment, use of prescription or medication, reproductive or sexual health care, gender affirming care, and it also includes information that is derived or extrapolated from non-health data, but that's used to identify or associate a consumer with consumer health data. So, for example, information about a consumer's purchase of a toiletry product by itself might not be consumer health data, but if your business provides a digestive tracking app and it collects that information, it is part of the app to give information about digestive trends, it would become consumer health. It may become consumer health data.
Yeah, interesting how something that seems completely unrelated all of a sudden falls within the scope.
Right.
Got it. Geofencing. How do these laws treat geofencing by businesses?
Yeah, all three laws prohibit geofencing within certain radiuses of entities that provide healthcare products or services, and they also prohibit certain collection activities around or within these restricted radiuses. That would include collecting consumer health data when they're within the radius, or sending notifications or advertisements that relate to the consumer's health data, or their tendency to go to these healthcare service providers for healthcare treatment. So if your business collects geofencing information, then you want to review what types of information you collect, how your geofencing radiuses are set up, and stop it if you're within the prohibited space. Then important to note that Washington's geofencing prohibition is in effect and has been since July.
Good to know. Good to know. In health data, one of the most protected, areas of consumer information out there. So, what are some of the protections that businesses need to be thinking about when it comes to employee access to that data, and making sure that unauthorized folks don't have access to it?
Yeah, this is particularly important. In Washington and Nevada, employee access must be restricted only to those employees who have a need to know, and that would include employees that have to have the information to provide the product or service. In Connecticut, employees must be subject to a duty of confidentiality. So a little bit different requirement there, but in all three laws, there's some level of employee access restrictions that must be instituted and enforced. So you want to review employee policies and procedures to make sure that employees are subject to these obligations.
Okay, so you just touched on 4 of your 5 areas. Applicability, finding or identifying if your business it falls within the scope of these requirements. The differing definitions of consumer and consumer health data, how geofencing is handled by these laws, and protecting this information from unauthorized or unnecessary employee access. Last one, consent framework. So what are the parameters for obtaining consumer consent for this information?
In Washington and Nevada, they introduced 2 concepts: consent and written authorization. In those states, you need consent to collect or share consumer health data unless it's reasonably necessary to provide the product or service, and you need written authorization to sell or offer to sell consumer health data. So a little bit different requirements here, and the laws are very specific about what disclosures you have to make when obtaining that consent, and they also prohibit obtaining consent to collect, share, and sell all at one time. You have to get individual consent for the different activities. And then in Connecticut, they amended their comprehensive data privacy law to include within the definition of sensitive personal information, consumer health data. So because of that, you have to have consent to collect consumer health data or sensitive personal information, and you have to have consent to sell or share it.
Gotcha. And as you're talking, it's hitting me, the importance of working with experienced counsel as you adapt your compliance programs to incorporate these, because as you said, there's a lot of nuanced areas. There are some requirements that are spelled out very explicitly, for example, geofencing restrictions. But when you use terms like, reasonably or need to know, employees, when we were talking about protecting against employee access and employees that have a need to know, those can be some pretty nuanced definitions. And so working with experienced counsel is important to make sure that you are staying on the right side of these laws.
Yeah, that's correct, and it's particularly important because the penalties associated with these laws. Now, all three laws give power to the state attorney general to enforce, so you'll have your penalties that can come from the state attorney general. But Washington also introduces a private right of action, which is kind of a first for privacy laws. We haven't really seen private rights of action being granted under these laws, maybe besides California's really narrow private right of action for data breaches. So penalties are high. Working with experienced counsel can definitely help to navigate the regulatory waters.
So going forward, as businesses continue to adapt their compliance programs to incorporate these and emerging new laws that are coming into play, aside from working with experienced counsel, what else should they be doing?
There's a few important things to do, but before I dip into that, it's important to note the effective date of these laws. Some are upon us right now. Connecticut's went into effect on October 1st of this year. Like I'd mentioned earlier, Washington's geofence prohibition is already in effect and has been since July. The remainder of Washington's law and Nevada's law will go into effect in 2024. So the time is now.
Yeah.
So businesses should determine the applicability of these laws and really do a data inventory to see if they're collecting the types of information that may be considered consumer health data. Then once you've done your applicability analysis, it's time to revise your privacy programs to incorporate these nuanced obligations. And then you should stay on top of these landscapes to see what other states may be coming up with their own privacy laws to stay ahead of the curve.
Gotcha. That's great. I hope that was helpful. Aaron, thank you so much for sitting down with me today and talking about this. I know that we will be having more information on this topic to come, as well as other areas of privacy, emerging areas of privacy. To stay ahead of, you talked about staying on top of what's going on. One way to stay ahead of the curve on both legislative developments and enforcement trends is to subscribe to our firm's news and insights. That's getting the latest information and practical insights from our attorneys delivered right to your inbox. You can get that information on the topics that are most meaningful to you, and you can do that on our website, mslawgroup.com/subscribe. And I think that was my plug. Thank you again, Aaron.
Thank you.
Great having you.